Good afternoon, everyone. I am Amy Rizzo. I'm the marketing manager for Kelleher and Holland. And this is the second installment of our monthly employment law focused lunch and learn webinars. And we hope that these short informational sessions are providing you with some insights that are relevant to your business. Before we get started, if you have a question at any time during the webinar, please type it in the Q&A question box located in your Zoom control panel. We're scheduled to go for 30 minutes today, but we plan to stay on to answer any questions you may have at the end of the presentation. Today's Lunch and Learn topic is the National Labor Relations Board's new menu, time to change the recipe for your severance and confidentiality agreements. If you attended our last webinar, that you will be familiar with our presenters today, two accomplished attorneys from our employment law group, Andy Bowling and Madeline Kelleher. So panelists, what's on your menu for lunch today?
Well, Amy, I've got some rabbit food in our office fridge, but I'd really like to have an Italian beef fully baptized with sweet peppers, but that's not on my menu today.
Sounds pretty good. My menu is a nice soup and sandwich. Why not?
Sounds great. My stomach is growling. So before we get started, we have a quick poll for our audience. Have you consulted with an attorney to review your confidentiality and severance agreements since February 21st of this year? So we'll get to why that date is significant in a little bit. And go ahead and fill out the poll on your screen. And we'll share the result of this poll at the end of our discussion today. All right, looks like we've got our results in. So let's get started. So Andy, if you kick us off today and let us know what our attendees will learn about.
Sure, thank you, Amy, and welcome everybody to our program. Today, we are here to talk about some very recent changes to the law relating to the validity and enforcement of severance agreements, in particular, two forms of restrictive covenants that often appear in severance agreements, and that is a non-disparagement provision and a confidentiality clause, and we'll talk more about what they mean later in our program. Now, why did we use February 21? Because our program had its inception in an important decision from the National Labor Relations Board, which we'll call the NLRB, that was issued on February 21, 2023, and followed up soon thereafter by a comprehensive guidance memorandum that was issued by the General Counsel of the NLRB in late March. Now, what are we talking about? What is the NLRB? The NLRB is a government agency that acts to protect public rights to, in essence, enforce the National Labor Relations Act, or which we'll often refer to as the NLRA today. Now, what is the difference? Like if you're a sports fan, consider the NLRA is like the rules of football, right? And the NLRB is the officiating crew. Who's calling the game? And as anybody who follows football or basketball knows, the composition of the officiating crew can make a big difference. As a general rule of thumb, the NLRB, which is a political body and changes every 4 years with the presidential election, you can consider a Republican-appointed NLRB is very much like the officiating crew that lets them play, and flags are to a minimum. In contrast, our current NLRB is a bit like, the Carl Cheffers or Sean Hockley officiating crews in the NFL that throw more flags and call more penalties than any other crew, in the rest of the NFL. So right now, it's a closely called game, so employers need to be careful. Now, the NLRA is typically viewed by people as something that applies only to unionized workforces. And indeed, we often see the NLRA used in the context of companies that have long-standing union relationships or in companies where unions want to create a presence. But it's a little known fact, and it's something that in these days when the NLRB is throwing lots of penalties against union and non-union employers, the NLRA protects employees of non-union workforces. So even if you don't have a union, you still have to pay attention to what the NLRB is doing. Now you'll hear Madeline and I will talk a lot today about Section 7 of the NLRA, and that is probably for a lengthy statute the most important, because this is really a short term that catches. It's the gotcha, if you will, for union and non-union employees. Section 7, and this, I promise, is the last thing that I'll read to you, provides that employees have the right to self-organization, to form, join, or assist labor organizations, i.e. unions, to bargain collectively, and here's the important part, to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. And that's where they suck in non-union employers. In the McLaren-McComb case, the NLRB said that the giving an employee a severance agreement is a violation of Section 7 if the wording of the severance agreement is overbroad. And again, that was followed up by a pretty sweeping general guidance memorandum issued by the General Counsel of the NLRB.
Great. Thank you, Andy. And if you could, Andy, let's back up for a minute and just kind of go over a definition of what a severance agreement is and what it contains.
Sure. A severance agreement is a binding contract that is often given by employers to an employee whenever the employee is receiving or has the possibility of receiving a discretionary termination benefit, such as severance pay, that they don't have a legal right to receive otherwise. And, it's a very good and common practice that if you're going to give up severance, you want to buy peace from litigation. And so employers have for decades put together, pretty formal, robust agreements to provide maximum protection to the employers to make sure that that's the last they'll hear from that particular employee.
All right, Madeline, let's get you involved here. Can you give some insight as to what has changed recently in the law regarding severance agreements?
Yeah, absolutely. So depending on the wording of the severance agreement, the very offer of the agreement to an employee can violate the law. So as Andy was explaining a little bit earlier, on February 21st of this year, the NLRB found that it is an illegal and unfair labor practice for employers to offer employees with severance agreements that contain overly broad non-disparagement and confidentiality provisions that, in any way impact an employee's right to exercise or refrain from exercising their Section 7 rights. So their reasoning decision can really be explained in a good 4 points. So first, the employer's mere offer of severance pay in exchange for restrictive covenants would deter the employee from exercising their statutory rights, as employees may feel that they must give up these rights in order to get the benefits such as severance pay that come with the agreement. Second, the confidentiality provisions that prohibit employees from discussing the actual terms of the agreement would prevent employees from exercising their right to have future discussions of a labor issue, dispute, a term or condition in or caused by the agreement, or even their right to engage with one another to improve their lot as employees as a whole. So for example, such as by discussing the severance agreement with another employee or a coworker to help him or her decide in the future whether or not to accept a severance agreement, him or herself. So next, third, the confidentiality provisions that prohibit employees from disclosing confidential information would impermissibly preclude the employee from assisting coworkers or former coworkers with workplace issues concerning their employer, as well as, preclude employees from cooperating with NLRB investigations and litigation of unfair labor practices, which would also be a violation of the employee's Section 7 rights. Finally, fourth and finally, a non-disparagement provision that broadly prohibits an employee from making public statements that would be unfavorable to the employer would violate the employee's Section 7 right to critique employers' policies by discussing or publicizing labor issues or disputes. So, however, the decision really comes down to defamation laws, meaning that the NLRB specifically provided an employee does not have the right to make statements that are considered, and this is a nice verbiage here, disloyal, reckless, or maliciously untrue.
So Madeline, the decision you just summarized, does it apply to all employees in a company?
Right. So just as Andy was discussing, first and foremost, everything you've heard about the National Labor Relations Act applying only to unions and union workers, it definitely also applies to most employees and employers in the private sector. So who doesn't get protected by this act? Generally, supervisors. So the NLRB's decision would normally not impact or apply to supervisors, except in two very limited circumstances, which would be when the supervisor is retaliated against by the employer for refusing to commit an unfair labor practice, such as by refusing to offer an unlawful severance agreement to an employee, or an employer offers a severance agreement to a supervisor among other things, prevent the supervisor from participating in an NLRB proceeding or assist other employees in exercising their Section 7 rights. So determining whether the employee is a supervisor is really more of an art than a science, and it's easy to make a mistake in this area. So, for example, some people may not know that engineers, many highly paid employees, and even lawyers are protected by the Act. Lastly, it's not going to be applicable to employees and employers not protected by the Act, which would include independent contractors, governments and government employees, or even employers in agricultural, railroad, and airline industries.
This new guidance seems like it's going to have quite an effect on future severance agreements and potentially other employee communications. So Madeline, can you shed a little light on how it will affect current severance agreements that are in play, and are they now banned?
So employers offering severance agreements that contain these overly broad confidentiality and non-disparagement clauses really now need to proceed with great caution. All employers should think twice about chasing down former employees who would be, or a former employee who would be violating the terms of a severance agreement. And this is really because the decision is retroactive, in effect, meaning that maintaining, enforcing, or seeking to enforce a severance agreement that already entered into, or entered into in the future that contains unlawful provisions is a violation of the Act. But to answer your, question on whether or not they're banned, severance agreements are still allowed as long as they don't contain these overly broad provisions that affect the rights of employees to engage with others to improve their lot as employees, which really doesn't just include talking about things with each other, with other employees. It includes the right to engage with the NLRB, their union, if any, judicial, administrative, or legislative forums, the media, or other third parties. And this really presents a question of whether your entire severance agreement would become invalid and unenforceable and in violation of this act if it contains one unlawful non-disparagement or confidentiality provision. So really, the NLRB explained that a sole defective or illegal clause will not invalidate the entire remaining provisions of the agreement. This is despite whether or not the agreement contains a severability clause, which I found interesting. Obviously, this does not mean by any means that severability clauses should be left out of a severance agreement, as it's a very important clause that helps ensure a provision found to be unlawful under the Act is not used as a basis for striking down other provisions, such as a general waiver and release of claims.
So Andy, what about non-disparagement provisions? Can they still be included in severance agreements?
Yes, they can, Amy. And Madeline and I typically take a two-pronged approach when we're advising our clients about the use of non-disparagement agreements. I'm going to talk first about the employees who are specifically and wholly protected under the NLRA, the non-supervisors. And there we tend to recommend a more, subdued approach, frankly, than we recommended before February 21 in the McLaren-McComb decision. They should be tailored to the situation at hand. And frankly, in most cases, we're not even using the term disparage, because that word by itself can be a red flag. I think there might be people within the NLRB, again, inclined to throw the penalty flag if they just see a clause that is called non-disparagement. In fact, we'll often place that in a section that might have other post-employment obligations, so it doesn't have a standalone title of non-disparagement. And it typically will be limited for our non-supervisory employees to statements that are disloyal, that are reckless or maliciously untrue, without providing a lot of explanatory context to what those admittedly ambiguous terms might mean, because we don't really know what that might be. And so we leave it at that and hope that the employee will get the gist of it and might think they're under some restraints, because I wouldn't want to have an overbroad clause for a non-essential, non-supervisory worker open the door for the NLRB to come in and not only challenge the agreements, but what they really want for all of you non-union workforces, this is kind of a Trojan horse, where once they are in your house, they want to stay and sprinkle, like a Johnny Appleseed of sorts, little union seeds, encouraging people to form unions in what has been a non-union workforce. So you'd like to keep them out of your house if you can. And so trying to be more subtle in your use is okay. Now, for supervisory employees, I think you need to look at the overall impact of the person who's leaving. If the person is a supervisor and they're also influential internally within the context of your organization, and or influential externally, they are well regarded in the industry, they have tight relationships with customers, with the media, maybe then you want to be a little more aggressive and not just use the magic words, and use something that is more traditional, coupled with kind of a broad disclaimer, the likes of which we'll talk a bit later in our program. So to circle back, yes, but it's not one size fits all. look at the employee, supervisor, non-supervisor, and if a supervisor, look at how influential they are and how important a non-disparagement clause might be at the end of the day.
Great. What about confidentiality provisions? Can those still be included?
You know, Amy, my answer is very similar to what I just provided on non-disparagement. Yes, but take a two-pronged approach. The upshot of the NLRB's decision and their guidance memo is you can no longer require a non-supervisor, even a former non-supervisor, to keep silent and not disclose what they got. And that was always a goal because most private businesses take an ad hoc approach to severance. In other words, there's no formal severance plan or policy. Companies that have a severance plan or policy don't need to worry about this so much because the employees can look at the document and kind of know, I worked 12 years, I'm going to get 1 week for each year of service. I'll get 12 weeks. There's no real magic to that unless that employee presents high risks. Maybe they've threatened to file a sexual harassment claim or some form of wrongful termination claim. So you're putting extra in there. Even if you're doing that, you still really, should proceed with extreme caution. It's like running through a light as it's changing red. Do you want to take that risk, especially if there's a camera there? Now, for supervisors, if you have an ad hoc, arbitrary place, you can be a bit more aggressive in asking that they keep it quiet. But I'm going to throw out one additional caveat. In states such as Illinois or California, and look on the East Coast for various municipalities, there are pay transparency statutes that say, even if you're a supervisor, even if you're a vice president, an officer of a company cannot, by contract or policy, tell that senior vice president that she cannot disclose how much she's getting paid, the amount of the bonus, any other perks, or the amount of a severance package. So the NLRB is not the only voice. You have to assume that there might be those replay officials sitting somewhere in state and local government who can throw flags, even if the NLRB officiating crew says it's no penalty. So look to where the person is located to see if you've got other hoops you have to jump through.
So Andy, what should employers do about their existing severance agreements that could contain these unlawful non-disparagement or confidentiality provisions?
Well, I'm going to parse here a little bit, Amy. And on that question, what do you mean by existing? If you mean an agreement, and this is a very fair question, that has already been signed, closed, you've paid out, in theory, at least for 6 months looking back, you should go back and say, hey, this overbroad provision is no longer legal. And we're not going to hold you to it. Frankly, I would tell my clients to avoid that as a matter of practice for all people. If you've got a real live wire, someone who's a troublemaker, someone who might try to squeeze more money or try to get something extra by relying on this, talk to your lawyer and see if it's worth that exercise. But right now, I wouldn't go back and set the record straight for agreements that are already closed. Now, if by existing, you mean our current templates, what should we do the next time we fire someone and offer severance and ask them to sign a severance agreement? There, I think you need to really dive in and look to see what needs to be changed. And just, I've seen the poll results. Less than 10% of the attendees have taken some action as a result of the McLaren decision on February 21, 2023. So this is a good time to look at your current agreements to see what do I have to change to make sure that you're really not going to be given no mercy by that officiating crew, because you've had almost 6 months to react and change your practices. So I would say absolutely going forward, get those agreements in shape.
Great advice, Andy. Thank you. Madeline, what should an employer consider when choosing to provide an employee who is separating from a company with severance pay?
Yeah, so elaborating a bit more on, Andy talking about existing or, really it's the contracts that are in development. There are 3 important considerations for employers when providing these severance agreements to employees that have severance pay. So first, they should consider an express statement in the actual agreement itself that really makes clear nothing is precluded, nothing in the agreement precludes employees from exercising their Section 7 rights. So even though the NLRB takes the position that disclaimer language like this in severance agreements would not necessarily cure overly broad provisions, they did acknowledge that it nonetheless can be useful to resolve ambiguity. And such disclaimers will likely strengthen an employer's arguments that the provisions do not attempt to inhibit any of the employee's Section 7 rights. So second, the NLRB also made clear that in determining whether the employee violated the act or employer violated the act, the circumstances surrounding the employer's offer or presentation of the separation agreement is irrelevant if the agreement contains restrictive covenants. So, you really need to make 2 things absolutely clear to the employee in offering a severance agreement. One, what restrictive covenants must be agreed to in order for the employee to receive the severance pay. And 2, that the employee's exercise of his or her Section 7 rights will not be inhibited, precluded by, or considered a breach of the severance agreement. Employers can also provide employees with a cover letter that reinstates and reinforces that the employee's Section 7 rights won't be impacted in any way by the agreement. Then third, the employer should also really be aware that including unduly harsh penalties for employees, an employee's breach of a severance agreement in any way may be unlawful, because such penalties are more likely to inhibit employees from engaging or in otherwise legitimate protected activities out of fear that, they'll incur severe financial consequences for violating this agreement. An example of a lawful penalty might be the employee's immediate return of back pay, frequently with interest, or payment by the employee of all costs and expenses in the resolution of an alleged breach of the agreement by the employee, including attorney's fees. But nonetheless, a provision that seeks damages from the employee that were caused by the employee's actual breach of the agreement would not be considered an unduly harsh penalty.
So Andy, to wrap it up, are there any other considerations that an employer should be aware of due to the NLRB's directives regarding these agreements?
Yes, there are a few. And in essence, we've talked today about severance agreements because read literally, the NLRB's guidance is restricted to, the termination process and what you ask employees to sign and the strings you attach to those agreements. But there's more to this story. They are going to be looking at the same provisions in your employee handbook and in your offer letters, in any kind of NDA, non-compete, confidentiality agreement that you sign with, you have your employees sign. And they often contain pretty robust non-disparagement provisions. So look at those, make sure that your confidentiality agreements give some leeway for discussion of wages and that only proprietary, personally sensitive HR information, which really is limited to employee medical questions, not compensation or benefits, that you allow employees the ability to share that, because we have to go back. We are currently in being officiated in a high penalty time. For the previous administration, it was fouls were called upon, broken bones or blood. And so there weren't many flags. But in the term before that, the NLRB was very similar. It was a high penalty crew, and they looked at terms of employee handbooks as a basis to sanction and take action against non-union employers. So look at all of your documents and policies.
Thank you, panelists. That was a lot of great information and insight. So I appreciate you sharing that with us. We do have a little bit of time for some Q&A. So just a reminder, if you would like our panelists to answer any questions live here, go ahead and type them in the Q&A question box in the Zoom control panel. And we do have a couple of questions coming in. First question is, can I use the same severance agreement in every state I have employees in?
I'll jump in and answer that, Amy and Madeline. I think that the answer is no, and that but is you can probably have 90% of the content of the release will be the same in all 50 states, with the possible exception of Louisiana, which has its own legal system. But there are huge state law differences. For example, Minnesota says, regardless of the age of the employee, you got to give them a 15-day kind of exit strategy, a revocation period. California requires a reference to specific statutes and pasting in as a best practice certain statutory language. So always look to the location where the employee is based to make sure that the release touches all the bases required by state and local law.
Great. We've got another question. Would an employee handbook that contains confidentiality and non-disparagement clauses also violate the NLRA?
Andy, I'll take this one. So
Okay.
I know you touched on it a little bit earlier, reiterating just simply issuing this employee handbook, if it contains unlawful disparagement or confidentiality clauses, is now a violation of federal law. So, it's even true in those employee handbooks with disclaimer language that, really denies the contractual formation and obligations. But, really employers, as Andy said, they need to take a good look at their policies and employee handbooks and any other contract that, is between an employer and employee to ensure that they don't contain any stray provisions that violate their employees' Section 7 rights under the NLRA.
Great. Thanks, Madeline. And we've got one more question that's come in. What if the confidentiality or non-disparagement clauses are mutual and agreed to be followed by both the employee and the employer?
I'll take this one as well. It's a very simple answer. It's even if these clauses are mutual, it will still violate the act if it contains this language that restricts or prohibits an employee's exercise of his or her Section 7 right. It's because the act provides that these rights cannot be waived even by the employee.
Yeah, and I'll kind of just tag on with kind of a closing, kind of remind people back to maybe schoolyard days. It's a little bit like if you have the mutual agreement, heads I win, tails you lose, because the employee, if they're protected, is going to be able to get out from under their non-disparagement clause. But if you, the employer, agree, we won't disparage you, employee, there's no getting out of that. Employers aren't protected, so you're going to be held to your contract, even if the employee breaches their obligation. So be careful when you negotiate those clauses.
And don't run after that employee for breaching that unlawful agreement.
For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.